Hello students, welcome to EPG Pathshala. I am Prakash Sharma from Faculty of Law, University of Delhi. Today we are going to discuss about a module, Women's Right to Succession and Inheritance in Hindu Law, under paper Women and the Law in subject Women Studies. The objective of this present module is, the purpose of this module is to trace the position of Hindu women vis-a-vis property rights from time of Shastric law to Hindu Succession Amendment Act of 2005 and the present emerging trends of Hindu law. Second, the lesson we will try to understand is to have an introduction to various legislative enactments in pre and post independent India towards securing property rights to women in joint family and co-partnership from property. The lesson further tries to sensitize the readers on discrimination against female over male in respect to their right to inheritance, the property of their family. Introduction. Every human being has a right to be treated equally in every aspect of life. However, position of woman is made to subjugation and oppression as she is made to suffer inequality with respect to her rights, more particularly her right to property. The patriarchal setup in India disregards the Hindu woman's right to property and brought her the position to be inferior in social and economic aspects of human relationship. In ancient times, Hindu women's property rights were provided with manifold limitations. However, attempts have been made in India to improve the position of Hindu women with regard to her succession and inheritance right with different legislative enactments in pre and post independent India. The Hindu Succession Act of 1956 was enacted to improve the succession rights of women. Yet, the position could not be improved, such and much has been expected, which has been reflected in 174th Report of Law Commission of India on Property Rights of Women, Proposed Reforms under Hindu Law. The report states that discrimination against women is so pervasive that it sometimes surfaces on a bare perusal of law made by the legislature itself. This is particularly so in relation to laws governing the inheritance succession of property amongst the members of joint Hindu family. It seems that this discrimination is so deep and systematic that it has placed women at the receiving end. On the recommendation of Law Commission of India in 2005, an amendment has been brought to Hindu Succession Act of 1956. The Act of 1956 improves the position of women further. In this module, we will try to provide a brief sketch pertaining to women's right to succession and inheritance in Hindu law in pre and post independent India. Background. In India, as far as personal laws, that is laws related to marriage, divorce and succession etc. are concerned, Hindus are governed by Shastric and customary laws which varies from region to region, community to community, caste to caste and even family to family. This brought multiple laws of diversified nature to govern Hindus which were prevalent in different schools and sub-schools like Mitakshara and the Abhanga. Both schools differ mainly on two accounts: the law of inheritance and joint family system. Mitakshara school recognizes two modes of devolution of the property, namely survivorship and succession. The rule of survivorship applies to joint family property and the rule of succession applies to property held in absolute severalty by the owner. The Abhanga school recognizes only one mode of devolution of property, that is succession. In this way, the property laws among Hindu become very complex. The main drawback of these laws is discrimination made by favoring males over female. The Mitakshara school recognized two kinds of property, that is joint family property and separate property. A joint family property consists of all persons lineally descended from a common ancestor and includes their wives and unmarried daughter. However, a Hindu coparcenary is a much narrower body than the joint family and includes only the persons who acquire by birth an interest in the coparcenary property. They are the sons, grandsons, and great grandsons. The cardinal doctrine of Mitakshara school is that the property inherited by a Hindu from his father, father's father, or father's father's father is ancestral property. That means unobstructed heritage as regards his male issues in which they acquire right by birth. A property inherited by Hindu from other relations is his separate property. The most important drawback of copartnery is that a female cannot be a copartner under Mitakshara law. Even a wife, though she is entitled to maintenance out of her husband's property and has to that extent has right in his property, is not her husband's copartner. A mother is not a copartner with her son. There can be no copartnery between a mother and a daughter. While considering the position of women in the family, a reference must also go to the concept of Stridhan. It can be described as a property which was given to women at the time of marriage as gift. Stridhan is the absolute property of a woman and she may dispose it of at her wish. The position of a female member in Hindu family was minimal. She had no independent rights. Women had not even been recognized in copartnery. Two types of property which a Hindu female could hold were Stridhan and woman's estate. Among these, two Stridhan were considered to be absolute property of a female Hindu. As far as Stridhan, she enjoyed full powers to alienate, sell, gift, mortgage, lease, or exchange during her maidenhood and widowhood. But certain restrictions were imposed on her power if she was married. On her death, Sridhan passes on her own heirs. The property in respect to woman's estate or widow's estate, the Hindu female owner had limited power of disposal. That is, she could not ordinarily alienate the corpus except for legal necessity, benefit of estate, and for religious duties. On her death, the woman's estate devolved upon the heirs of last full owner known as reversionaries, who are the male relatives. In the joint family system, under patriarchal setup, the like Mitakshara copartnery, though women were treated as members of joint family, she had only right to sustenance, but she was not vested with control and ownership of property and not admitted into copartnery. Doctrine of son's birth right was followed, concomitant to the principle of devolution of survivorship of the joint family property to a group called copartners, which comprises of son, grandson, and great grandson. Thus, no Hindu female was a member of copartnery in Mitakshara law and she was excluded from inheritance. Making the improvement over above mentioned Hindu women's position, in the pre-independence period, two legislations, the Hindu Law of Inheritance Act of 1929 and Hindu Women's Right to Property Act of 1937 were passed. Pre-independence developments. In pre-independence India, Hindu Law of Inheritance Act 1929 was the earliest legislation which brought the Hindu females into scheme of inheritance. Three female heirs, son's daughter, daughter's daughter, and sister were conferred the right of inheritance under the Act. Second landmark legislation is Hindu's Women Right to Property Act 1937, which brought revolutionary changes and also tried to ensure that in the Mitakshari copartnery, the widow of the deceased would take the same interest which her deceased husband had in the joint family property at the time of his death. She was made entitled to claim partition as a male owner. However, in all cases, she took as a limited owner. The widow, though a member of joint family and having right in copartnery interest, she was not a copartner. Although these legislative enactments conferred few rights of succession on certain women, they failed to protect women against discrimination. widow of the owner of a separate property was also granted the right to inherit along with the son. Post-independence development. With the dawn of independence, the framers of Constitution took note of inequality which has been perpetuated against women, depriving them of social economic justice as envisaged in Constitution of India. Consequently, amid strong resistance from Orthodox Hindu section, the Hindu Succession Act was enacted in 1956 and came into force on 17 June 1956. The Hindu Succession Act of 1956. The provisions of Hindu Succession Act of 1956 were made applicable to all Hindus, including Buddhists, Jains, Sikhs, and laid down a uniform and comprehensive system of inheritance, and applies to those governed by Mitakshara and Dayabhaga schools as well as any other school. Not only this, it was an answer to the need of progressive society and an improvement over the old Hindu textual law related to succession among Hindus. For example, the non-inclusion of female relative to inherit the property and giving preference to males. It tries to remove inequality somehow between male and female with respect to right to property and also bring revolutionary changes so as to recognize the right of inheritance of Hindu females at par with the males. Both male and female relatives are declared to inherit the property simultaneously and in equal share. Mother, widow, son and daughter are all co-heirs. The Hindu Succession Act of 1956 came under heavy criticism for retaining only males as co-partners in joint family Mitakshara co-partnery. Section 6 of the Act provided that whenever a male Hindu having an interest in the Mitakshara co-partnery property died after the commencement of this Act, then his interest in property would devolve by rule of survivorship and not in accordance to the Act. However, proviso to Section 6 incorporates that when Mitakshara co-partner died, leaving behind a female heir of class 1 or a male heir claiming through her, then the interest would devolve by testamentary or intestate succession, in accordance with the Act and not by the rule of survivorship. Therefore, it is evident from the Act that Hindus female could not inherit ancestral property by birthright and was excluded from joint family co-partnery under Mitakshara system. For instance, if a joint family property was divided, then each male co-partner took his share and female got nothing. Only when one of the co-partners died, she got share in the interest as an heir to the deceased co-partner. Moreover, by virtue of Section 4, Clause 2 of the Act, woman has been placed in unequal position to that of males with regard to inheritance of tenancy rights in agricultural land. Further, Section 23 again disentitle a female heir to seek partition in respect of dwelling house wholly occupied by members of family until the male heirs choose to divide their respective shares. Section 24 of the Act make three kinds of widows: intestate predeceased son's widow, or the widow of predeceased son of a predeceased son, or widow of a brother disqualified in succeeding to the property of the intestate on their remarriage during the lifetime of intestate. Thus, Hindu Succession Act 1956, instead of promoting gender equality, perpetuated gender discrimination through some of its provisions. Apart from the criticism, the Hindu Succession Act 1956 reformed the personal laws of Hindus and conferred upon Hindu women absolute and full ownership of property instead of limited rights to property. Section 14(1) of the Act provides that any property possessed by a female Hindu, whether acquired before or after the commencement of this Act, shall be held by her as a full owner thereof and not as a limited owner. Further, through the explanation appended to subsection 1 of Section 14, enumerates different methods by which women may be acquired property or would acquire property, and states that property includes both movable and immovable property acquired by a female Hindu by inheritance or device, or at the partition, or in lieu of maintenance or arrears of maintenance, or by gift from any person, whether relative or not, before, at or after her marriage, or by her own skill or exertion, or by purchase of, or by prescription, or in any other manner whatsoever, and also such property held by her as Sridhan immediately before the commencement of this Act. The object of Section 14 is twofold. A. That is to remove disability of a female to acquire and hold property as an absolute owner. B. To convert any estate already held by a woman on the date of commencement of the Act as a limited owner into an absolute estate. A female Hindu, after the commencement of this Act, is given any property with certain limitations. She would hold that property subject to those limitations and cannot acquire those properties as an absolute owner. The limitations are set out in subsection 2 of section 14, which runs as follows. Nothing contained in subsection 1 shall apply to any property acquired by any of the gift or under a will or any other instrument or under a decree or order of a civil court or under an award where the terms of the gift, will or other instrument of the decree, order or award prescribed a restrictive estate in such property. Section 14 Clause 2 is an exception to Section 14 Clause 1, and it enacts a well-established principle of law that if grant is given subject to certain restrictions, the grantee will take the grant subject to those restrictions. Thus, in the absence of any provision in will, gift, decree, order of the civil court, award of any other instrument prescribing any restricted estate on female Hindu, she would take an absolute estate. Section 14 Clause 2 applies to instruments, gifts, decrees, awards, etc., which create an independent right on new title in favor of Hindu female for the first time and not in recognition of pre-existing rights. Since the female is made the absolute owner of property held by her, general rules of succession to the property of a Hindu female dying intestate and order of succession in according to section 15 and 16 of the Act. Section 15(1) provides that if a female Hindu dies intestate, then the property will devolve according to the rules set out in section 16, as firstly upon the sons and daughters, including the children of any predeceased son or daughter, and the husband. Secondly, upon the heirs of the husband. Thirdly, upon the mother and father. Fourthly, upon the heirs of the father. And lastly, upon the heirs of the mothers. However, if a female Hindu dies, issueless, leaving behind no child or grandchild, then different rules will govern the matter of succession to her property, depending on whether she has inherited property from her father or mother or from husband or father-in-law or has acquired it from some other source. Section 15 does not apply to property held by a Hindu female with restricted rights, that is provided in Section 14 Clause 2 at the time of her death, but applies to case where she became a fresh stock of descent. Under subsection 2 Clause A of Section 15, if a Hindu female inherits any property from her father or mother and she dies without children or grandchildren, then her property devolves on the heirs of her father. Reforms in succession through state amendments. Acknowledging the discrepancies in regard to Hindu women's position in Mitakshara Kopasnari, certain states like Kerala, Andhra Pradesh, Tamil Nadu, Maharashtra and Karnataka in India took cognizance that for economic and social justice to prevail, women must be treated with equality. Accordingly, the Kerala Joint Hindu Family System Abolition Act 1975 completely and fully abolished males' right to birth to property and brought an end to the joint Hindu family system. No one can claim any interest in ancestral property on grounds of birth in the family. By making amendments to Section 6 of Hindu Succession Act 1956, the state of Andhra Pradesh, Tamil Nadu, Maharashtra and Karnataka in 1986, 89, 94 respectively declare that daughters are co-partners in joint family property. As per the Amendments Act of these four states, only a daughter who was unmarried at the time of the amendment would be entitled to a co-partner by birth in her own right in co-partnery property and be subject to similar liabilities and disabilities as incurred by sons. Thus, by virtue of these amendments, dual rights have been conferred on daughters, as on one hand she becomes co-partnership property right owner in her natal joint family, and on the other hand she becomes a member of marital joint family after her marriage. The 174th Law Commission report. According to this report, state amendments only brought sweeping reforms in their respective places. But Hindu women in other states of India continued to be subjugated to inequality in relation to their property rights because of the shortcomings of Hindu Succession Act of 1956. To ameliorate the position of Hindu females, initiative was taken by Law Commission of India, which in its 174th report on property rights of women proposed reforms under Hindu law under the chairmanship of Justice B.P. Jeevan Reddy, made important recommendation stating that discrimination against women is writ large in relation to property rights, social justice, and demands that women should be treated equally both in economic and social aspect. The recommendation of the Law Commission of India found reflection in Hindu Succession Amendment Act of 2005 with the amendment of Section 6 and omission of Section 4 Clause 2, 23 and 24, which had under Hindu Succession Act of 1956 perpetuated gender biasness and inequality. In the year 2008, the Law Commission of India in its 207th report under the chairmanship of Justice A.R. Lakshmanan recommended the proposal to amend Section 15 of Hindu Succession Act of 1956 in case a female Hindu dies intestate leaving her self-acquired property but no child or grandchild is present. This proposal has not been incorporated in Act till date. The Hindu Succession Amendment Act 2005 Amendment Act of 2005 deleted Section 4 Clause 2 of Hindu Succession Act 1956 and paved the way for women's inheritance in agricultural lands equally to that of males. The amendment has done away with the discriminatory state-level territorial laws and benefited many women who are dependent on agriculture for their sustenance. The Hindu Succession Amendment Act of 2005 has addressed a very pertinent matter relating to rights of daughters in Mitakshara Kopasnari and thus elevated daughters' position by amending Section 6 of Hindu Succession Act of 1956. The amended Section 6 deals with devolution of interest in Kopasnari property. Section 6 Clause 1 provides that the daughter of a Kopasnar in a joint family governed by a Mitakshari law school shall, on and from the date of commencement of Hindu Succession Amendment Act of 2005, by birth, become a co-partner in her own right in the same manner as the son. She shall have the same rights and be subject to the same disabilities in the co-partnership property as that of son, and any reference to Hindu Mitakshara co-partnership shall be deemed to include a reference to a daughter of a co-partner. But this provision applies to both married and unmarried daughter before the commencement of Amendment Act 2005. Any disposition or alienation, including any partition or testamentary disposition of property, which had been taken place before the 20th December 2004, shall not be affected or invalidated by provision in Section 6 Clause 1. Proviso to Section 6 Clause 1 defines this particular aspect. Further, any property to which female Hindu becomes entitled by virtue of subsection 1 of Section 6 shall be held by her with the incidence of co-partnership ownership and shall be regarded as property capable of being disposed of by her by will and other testamentary disposition. The provision also provides that where a female dies after the commencement of Hindu Succession Amendment Act 2005, his interest in the property of a joint Hindu family governed by the Mitakshara law shall devolve by testimony or intestate succession under the Act and not by survivorship, and the co-partnership property shall be deemed to have been divided as if a partition has taken place. Further, the daughter is allocated the same share as is allocated to a son. Section 3, Section 6, Clause 3, subsection A, and that the share of the precedent son or a predeceased son or a predeceased daughter as they would have got had they been alive at the time of partition shall be allocated to the surviving child of such predeceased son or of such predeceased daughter. Further, the share of predeceased child of a predeceased son or of a predeceased daughter as the child would have got had he or she been alive at the time of partition shall be allocated to the child of such predeceased child of the predeceased son or a predeceased daughter. The explanation appended to section 6.3 highlights a important fact. Interest of Hindu Mitakshara Kopasnar shall be deemed to be the share in the property that would have been allocated to him if a partition of the property had taken place immediately before his death, irrespective of whether he was entitled to claim partition or not. Thus, by virtue of amended section 6, daughter of a Kopasnar has become a Kopasnar in the Mitakshara joint family property and has the same birthright as that of son, with same rights and liabilities. Daughters will now get a share equal to that of sons, and at the time of notional property, just before the death of the father, and an equal share of father's separate property. In Prakash versus Fulavati, 2016, the question arose whether the right of a daughter to be a Kopasnar would be applicable to living daughters of living Kopasnars as on 9 September 2005, that is the date of enforcement of Amendment Act of 2005, irrespective of when such daughters were born, or would the amendment in section 6 of the Act 1956 be applicable to daughter born after the said date. The Supreme Court held that this right is available to daughters living on the date of amendment, irrespective of the fact that when they were born. Similarly, in Donamma versus Amar, 2018, adding to the authoritative pronouncement of Prakash versus Fulavati case, court held that the rights of appellant got crystallized in the year 2005 itself, and thus the share in the partition suit shall evolve upon the appellants as well. Further, court confirmed that amendment to section 6 statutorily recognizes the right of daughters as Kopasnars since birth. It is the factum of birth that creates the Kopasnari. Therefore, the sons and the daughters of Kopasnar become Kopasnar by virtue of birth. Though the amended section 6 is a significant advancement towards gender equality and economic security for daughters, yet other females such as mothers have not been given recognition as Kopasnars. Justice and equality cannot be secured for one category of women at the expense of other. Therefore, law must be changed to confer all Hindu women equal property rights in ancestral as well as separate property. Section 23 of Hindu Succession Act 1956 has been omitted by the Amendment Act of 2005, as a result of which at present all daughters, both unmarried and married, are entitled to same rights as son to reside in and to claim partition of their parental dwelling home. The Amendment Act of 2005 has also omitted Section 24, which had disqualified certain widows on remarriage from succeeding to the property of intestate. Now, the widow of a predeceased son or the widow of a predeceased son of a predeceased son or widow of the brother can inherit the intestate's property even if she has remarried. Moreover, the Amendment Act 2005 has added some more heirs to the list of Class 1 heirs, who are daughter's daughter's daughter, daughter's son's daughter, and son's daughter's daughter, and daughter's daughter's son. Conclusion. The position of Hindu women in respect to her property right has undergone unprecedented transformation from ancient time to the Hindu Succession Amendment Act of 2005. The journey from exclusion to recognition of Hindu daughters in Mitakshara co-parsonary have been remarkable. In spite of some progress brought by Hindu Succession Act of 2005, females are still denied their lawful rights in the predominant patriarchal society. Silence and self-denial on the part of women of being subjugated to unequal property rights reinforces and further perpetuates injustice. Hindu women must be made aware through legal literacy campaigns and social awareness programs about their property rights so that they may fight for what is rightfully theirs by virtue of being born as a human beings. Concerted efforts on part of government, non-governmental organizations, public and women should be taken up to bring about attitudinal change in the mindset of promoting equal rights based on humanity for achieving gender equality. Thank you.